Nortel failed a few years ago, and one particular entity got together and bought up the patents for a hefty chunk of change. The entity isn't what you would think. It's a conglomeration of Apple, Microsoft, BlackBerry, Sony, Ericsson, all together under perhaps an appropriate moniker, Rockstar. Right now, Rockstar, which is not really using the patents but maintaining the patent portfolio, is in a controversy with Google over possible infringement of those patents. Rockstar filed a lawsuit for patent infringement in the Eastern District of Texas recently, in October of 2013, based on patent infringement against not Google but some of Google's partners like Samsung and HTC over the Android phone. Google was none too happy about that and decided to file a lawsuit that would be a declaratory judgment declaring non-infringement in the Northern District of California. Rockstar, of course, didn't respond very kindly to that and filed a motion to dismiss that particular action. In July, Judge Wilkin in the Northern District of California denied Rockstar's motion to dismiss. So Rockstar then, this is a tennis match, added Google to the lawsuit in the Eastern District of Texas, and Google then filed a motion to transfer that back to California. So we have these competing lawsuits in the Eastern District of Texas and in California. And just last week, Google filed a mandamus action in the Federal Circuit in D.C. that sought to overturn the Eastern District of Texas ruling as an abuse of discretion. So, Paul, will you please make sense of this for us?
Well, Megan, this is a forum contest, and patent disputes are known for that. And this is a special forum contest because it's parallel litigation. We've got two cases going at once rather than just an objection to one venue. And but it also involves patent venue, which is a special, very broad venue statute that allows filing any place where a defendant resides or an infringement occurred. And so it is a wide open venue statute, and it's challenged very often, and that's why we have these. We also have in patent practice a lot of race to the courthouse, which we had in this case too. At this moment, and you said we had a personal jurisdiction objection and some other things, at this moment it is an inconvenient forum objection that is going in front of the Federal Circuit. That test is based on both public and private factors. It's a multi-factor test, and all of them depend on the factors in each one of those cases.
Does that mean just where the most convenient forum is going to be, the Federal Circuit will determine where the litigation should proceed?
And not at all. Under the long case law for inconvenient forum transfer, the court is supposed to defer to the plaintiff's choice of forum unless that choice would be seriously inconvenient for the defendant. The convenience goes to getting witnesses there, the cost of litigating there, any number of other factors that will vary from case to case. And it depends in this case on how well Google presented its argument there. And even though, they lost in the Eastern District, that argument will go up for review now with the Federal Circuit. As to how that could come out, anybody could guess. But I think it's interesting that Google did not object. Google argues that this case has nothing to do with the Eastern District of Texas. If that were true, they could have objected to jurisdiction in the way that Rockstar did and lost in California, or they could object to wrong venue and get a transfer. They didn't do that. They're saying it's seriously inconvenient for them. They lost in the Eastern District. We'll have to see how the Federal Circuit reviews that. And again, the Federal Circuit has to defer to the Eastern District judge on that unless the Eastern District abused its discretion in finding that.
So how do you think it's going to come out?
I'd flip a coin. And that's true not just with patent transfers. It's true with any number of cases. They so much depend on the facts in that case that it's, if I heard the argument in court, I'd still have to wait till the court ruled to know how that was going to come out.
Well, thank you.
Thank you.